All right, we're back. So Ted Baruti has done some crack research for us just to, in light of the last question on the last panel, we were talking about the two Intel cases, one win in that case, one loss, but Ted was pointing out, turns out there's at least 6, perhaps 7 patent trials in the Western District of Texas, and I think it's 2 plaintiff wins and 4 or maybe even 5 defense wins. So take that all with a grain of salt. It is, as I think Professor Anderson mentioned, a small sample at this point. And beyond that, I'll add a point that there is probably some selection going on, and there's selection effects potentially in play there that may impact what the statistics really mean. But at any rate, we're back. And so we're going to proceed on and talk about our second panel. And the title of our second panel is Arthrex, the PTAB, the USPTO director's new, perhaps temporary, authority over patent opposition proceedings. And let me first introduce our panelists. Another great panel, we've got Tejas Naranchania. He's the Robert and Nancy Corson Assistant Professor of Law at the University of California, Berkeley School of Law. He's also a faculty co-director of the Berkeley Center for Law and Technology. He graduated with a Bachelor of Science in Electrical Engineering and Computer Science as well. And beyond that, he also has a Bachelor of Arts in Political Science from UC Berkeley. He later earned his JD from Columbia Law School. He also clerked. He clerked for Judge Diane Wood at the Seventh Circuit, and as well for Justice Breyer at the Supreme Court. He also served as a special counsel for the FCC, where he advised the agency on network neutrality matters. We also have Jason Rantanen. He's the director of the Innovation Business and Law Center and the David L. Hammer and Willard L. Sandy Boyd Professor, which is a mouthful, both at the University of Iowa College of Law. He earned his Master of Arts in History from the University of Chicago. He earned his JD from the University of Chicago Law School. He clerked for Judge William Bryson on the Federal Circuit. He also worked at Munger, Tolles, and Olson, focusing on patent litigation and counseling. Our third panelist is Dr. Crystal Shepard. She's an adjunct professor of law at both the Nebraska College of Law and the University of Minnesota Law School. She's also a distinguished fellow and faculty with the Nebraska Governance and Technology Center. She graduated from the University of Michigan with a Master of Science and a PhD in Cellular and Molecular Biology. She earned her JD from Cornell University Law School. Dr. Shepard was previously the first regional director of the Elijah J. McCoy Midwest Regional U.S. Patent and Trademark Office in Detroit. She's also worked at the law firm of Foley and Lardner, the U.S. International Trade Commission, and as chief counsel on patents and trademarks for the United States House of Representatives Committee on the Judiciary. So welcome to all of you. And Professor Rantanen, I believe we have you setting the stage for this panel by explaining better what happened in the Arthrex case.
Sure, David. Well, thank you for inviting me. I am delighted to be here and to be able to talk to you. I'm going to say a little bit more about some of my own thoughts in just a moment. But to get us started, I'm going to talk a little bit about Arthrex and just the decision, what it did, what it meant. All right. So United States versus Arthrex originated in the Patent Trial and Appeal Board after the challenger, Smith and Nephew, filed a petition for inter partes review of a patent Arthrex owned, claiming a knotless securing assembly. Now, after trial, the PTAB concluded that the challenger had shown through a preponderance of evidence that the instituted claims of Arthrex's patents were unpatentable. Now, Arthrex, of course, appealed the decision to the Federal Circuit, arguing to the Federal Circuit that the administrative patent judges on the PTAB were unconstitutionally appointed. The Federal Circuit ruled in Arthrex's favor, agreeing that the PTAB judges' appointments were an unconstitutional violation of the Appointments Clause of the U.S. Constitution. The Federal Circuit came to this conclusion based on the extensive power administrative patent judges hold when adjudicating patent rights in inter partes review proceedings, coupled with the fact that neither the Secretary of Commerce nor the Director of the PTO, both of whom were principal officers, had the direct authority to review the judge's decisions. And because the director, a principal officer, lacked the authority to review the judge's decisions, the Federal Circuit reasoned that the administrative patent judges couldn't be inferior officers. Instead, they seemed to be wielding the power of a principal officer. Now, this matters because while an inferior officer may be appointed by the head of a department, appointment of a principal officer requires the advice and consent of the Senate, something that isn't done with APJs. The Federal Circuit's solution, however, sought to do an end run around all of this by just eliminating the job protections of APJs so that the director could terminate them at will. All right, so the Supreme Court subsequently granted cert, and in United States versus Arthrex, it held that 35 U.S.C. Section 6C, which sets forth the authority of an administrative patent judge, is unconstitutional because APJs effectively wield the power of principal officers while being appointed as inferior officers, basically the same conclusion as the Federal Circuit. As the court explained, only an officer properly appointed to a principal office may issue a final decision binding on the executive branch. And at the PTO, it was the APJs who issued the final decisions in PTAB proceedings, not the director. And since the director didn't have the direct power to review the decisions of the PTAB, they really were the final decisions of the PTO. Okay, so the court's remedy, on the other hand, was even more creative than that of the Federal Circuit. What it did was to grant the director the authority to review the PTAB decisions. So job protection's okay, but instead we're going to have this new procedural mechanism to allow the director to review the PTAB decisions. Now, the creativity in the solution wasn't in coming up with it. Chris Walker and Melissa Wasserman had suggested it in the New World of Agency Adjudication in 2019. The court's creativity was instead the fact that it made what was basically a wholly new procedural mechanism outside the statutory review framework for giving the director final decision-making authority. And if we think back to the last panel, I think this is a really remarkable thing. Now, this was hardly an unfractured decision. The justices had a variety of different opinions here, but the end result was to grant the director the authority to review final PTAB decisions and to issue decisions on behalf of the PTAB. Okay, so to put this all into context, even before Arthrex, the director had significant control over PTAB proceedings. The director appointed panels of APJs to hear cases, and in the event the director disagreed with the final written decision of the APJ panel, there existed a form of director review through the POP, Precedential Opinion Panel process. In the event the director wanted to review a decision, the director was able to appoint a new PTAB panel to rehear the case, with the director having one of the 3 votes on the POP panel. But perhaps even more importantly, as Tejas is going to talk about in a moment, the director could also initiate rulemaking or issue guidance to the Patent Office. Now, since Arthrex, the USPTO has been charting its path forward for devising and implementing agency rules in response to the US Supreme Court's decision. After the holding in Arthrex, a final written decision of an APJ can be reviewed by the director in 2 ways. First, the director can choose to review the decision sua sponte. Second, either party can request director review following a decision of an APJ panel. Requests for director review must be filed within 30 days of the PTAB's final written decision or rehearing decision. Now, upon receiving a request to review a decision or deciding to review sua sponte, the director can fully grant, partially grant, or deny a party's request for review, or could instead remand the case to the PTAB panel along with instructions. In either event, both parties retain the right to appeal the final decision to the Court of Appeals for the Federal Circuit, something I'll be talking a little bit about more in a moment. So this then is the new landscape, a greater role for the director once the PTAB administrative patent judges have issued their decisions. A greater role that was judicially created rather than legislatively enacted. So I'm going to turn it back over to David now, who will introduce our next speaker.
Great, thanks. That was an excellent summary of the Arthrex case. So here we are, right? We have the Arthrex case. I've heard there's rumblings of members of Congress. They may have a desire for a different structure or a review authority. And so this panel is going to consider the Arthrex decision, what it means for the patent system, with an eye towards, I think, identifying the appropriate mechanism for ensuring both accurate decision-making over invalidity disputes while recognizing the political accountability required by the Appointments Clause. And I think that leads me to turn it over to Professor Naranchania.
Thanks. So let me start by saying thanks to you, Professor Taylor, for the invitation to join, to the Sci Center and to SMU for putting together this great event, and to my co-panelists, Dr. Shepard and Professor Rantanen, for what I'm sure will be a lively discussion. So I want to pick up where Jason left off and try to put Arthrex in the larger context of the Supreme Court's now 2-decade-old foray into what I've called recently administrative patent law, right? The intersection between patent law and administrative law. And the Supreme Court begins this path into administrative patent law with Dickinson. So in Dickinson versus Zerko, the question that the court is asked to decide is whether Federal Circuit review of fact-finding must accord with the APA. And consistent with what the Supreme Court has done in a lot of cases, it says yes, right? We treat the patent system the way we treat everything else. Procedural rules, administrative law rules, these are the same for the patent system as they are for any other area of law. But the reason that the court gives in Dickinson is a reason that's really grounded in expertise. What it says is that the Patent Office is the expert agency. Patents are technical. And so the Patent Office is well deserving of the sort of judicial deference that the APA envisions. Other cases, JEM, other cases around this time likewise seem to emphasize the Patent Office's expertise in the court's understanding of the patent statutes, patent procedures, the way we ought to run the patent system. But I4I is sort of the beginning of the end of expertise as the dominant value in the court's, in the Supreme Court's construction of this administrative patent law. So I4I, as you probably remember, is this case about the presumption of validity. And what the court does in I4I is it rejects the presumption of validity's traditional foundation in the Patent Office's expertise and writes a whole new one for it, so based in common law constructions of statutory language. So if I4I is the beginning of the end of expertise for the dominant value, what starts to replace it? What starts to replace it, I think, are concerns about agency flexibility, and agency flexibility in particular over and across political administrations, where there's a concern for political accountability in the patent system. Quoto has a little bit of this. There are hints of emphasis on agency flexibility, the idea that the agency should be able to take a second look at the patents that it issues, the idea that the agency retains the flexibility to revisit the IPR claim construction standard. It's something that the agency in fact does under Director Iancu. Oil States similarly emphasizes flexibility. Oil States also hints that the recourse for unfair exercises of this agency flexibility is political. Right? If you have a problem with that, it's not in the 7th Amendment, it's not in Article 3, it's at the polls. And Arthrex, so why am I talking about all of this? I'm talking about all of this because Arthrex is, I think, the culmination of the court's project, or maybe this court's project, of moving away from expertise and towards political accountability. Because what Jason just said, and I think it's really important to highlight, what the court does by its remedy in Arthrex, right after it interprets the appointments clause and the executive vesting clause and sort of figures out what all of that means for the Patent Office and the PTAB, what the court does is it subordinates the agency's expert technical adjudicators, the members of the PTAB, to the agency's political leadership. Congress had it the other way around, and the court says you can't do that and flips it. And that's pretty remarkable, right? When Jason said that the court was creative in its remedy, it was really creative. It rewrote the statute. And I think that's big and that's important. And you wouldn't know it by reading the opinions. Right? So if you just read, for example, the majority and the principled dissent, the fight between the majority and Justice Thomas is really not about whether or not this is the right call, but how much political accountability you need. Justice Thomas is saying, look, like Jason said already, the director has lots of powers. It can deinstitute, it could set a precedential opinion panel, it can order rehearing, it can do all these things, it can stack the panel, it can do all these things, that's enough, right? That's the sort of political, that's enough political accountability. The majority says, no, that's not enough, right? If you want political accountability, you have to go all the way. And the director has to be able to review this. All right, so what? So that's what Arthrex does. I think that's a big deal, but let me tell you why I think you should care about this big deal, other than that it's just big. One, political accountability matters. It matters to this court. It matters across administrative law areas, and patent law is no different. So, this is maybe the CLE takeaway. If you find yourself writing a cert petition, or you find yourself in a merits brief at the court, it might behoove you to emphasize questions of political accountability and accountability matters. And I think we're starting to see some of this. So if you look at some recent cert petitions that were filed in, say, cases about the FinTIP standard, there are hints of sort of saying, look, what the director did was inconsistent with the sorts of political and democratic accountability we typically expect from the administrative law system. So that's one takeaway. The second is, we should ask whether or not we think the sort of political accountability is good. And I'm going to say yes. I think it's good. Patents are political. Patents are inherently political in that we have competing patent ideologies, different views about what makes for good patent policy, what makes good for good innovation policy. And I think we are better served with a patent system that ensures that the process of settling those policy disputes is democratically legitimate, right? That has mechanisms of political accountability, transparency, and that there are ways for us, either as the public or as members of, what Kelly Murray has called the Patent Civil Society, ways for us to respond to the decisions that patent agency leadership makes. I'm going to stop there because I'm sure there will be responsive comments, but I have plenty more to say.
Great, thank you. Actually, let's go back to Professor Rantanen and have his opening remarks now.
Thanks, David. Let me see if I can share my slides here. I've got a lot to say on what Tejas was just talking about, but I'm going to give a little different perspective on something else for a moment. Let me see if I can do this right. Oops.
And I've confirmed you do have the ability to share.
Okay. Sorry, I didn't test this ahead of time. Let me just do this real quick. Apologies.
You're good. And while he's getting that set up, I'll just encourage, everybody, again, I'll have several questions, but I do want to encourage you to submit your own questions using the Q&A feature.
All right, so here we go. You can see my slides, right? We're all good? All right, great. Terrific. Okay, so what I want to talk about is the possibilities of what happens in all of this. So in Arthrex, as we've talked about, the Supreme Court creates this new procedural mechanism in which the director can review the decisions of the PTAB judges. In particular, I want to focus in on IPRs because I think that's a lot of what's going on. I think we have some questions about the extent to which the director is going to be really involved in reviewing decisions involving denials of applications. Let's focus in on IPRs. So rather than just directly appealing to the Federal Circuit or filing an action in the Eastern District of Virginia, a party that's unsatisfied with the outcome of a PTAB decision can now petition the director for rehearing. Now, Professor Narachania describes the shift in the court's jurisprudence away from technocratic decision-making and towards what he calls political accountability. And he argues that this is a good thing, that political accountability means settlement of competing patent ideologies. Now, I'm not quite as sanguine about the meaning of political accountability, at least when it comes to adjudicative decision-making about rights being conferred or taken away by the government on an individual level. And I think, indeed, one could see the role of political accountability as rewarding allies of the current president and maybe penalizing those who are out of favor, maybe even on an individual level. And I think that's where I get most trouble. I'm also skeptical that the average voter places much significance on patent policy as opposed to lots of other things. And even then, it seems like Congress would be a much more direct vehicle for achieving major policy changes on patent law. So I'm kind of skeptical about this. I have some concerns about it. But that said, my sense is that as PTO review is currently structured, there's really relatively little room for the director to engage much in policy shaping through review of individual PTAB decisions. As Professor Narachani observes, there are many other ways in which the director can influence patent policy, and I think those are likely to be much more promising paths than exercising direct oversight over individual PTAB decisions. Now, there are two reasons why I reached this conclusion. First, an enormous portion of final written decisions in inter partes review proceedings by the PTAB end up being appealed to the Federal Circuit. In other words, the Patent Office is very much not the last stop when it comes to these decisions. Now, I like to use, let me see if I can advance this, yay. I like to use an image of an iceberg to illustrate the basic concept of how cases successfully move through the system. At each stage, some cases drop out and some move on as we get smaller and smaller towards the point of this iceberg. Understanding which cases drop out and which move on is really important from my perspective to understanding the entire system. This is what a lot of my research focuses on. So to demonstrate how this applies here, I drew on the PTO's data of decisions. Now the PTO makes its data on PTAB decisions available on the website through a terrific API. You can go there, you can check it out. And what I did using the PTO's API is I just searched for AIA trial IPR that had final written decisions from the period January 1, 2010 to October 20, 2021. So this period, and I made it extra long just so I could make sure I could capture everything. This gave me 2,477 final written decisions in unique IPR proceedings. Now, using the PTO's own docket number for these proceedings, I matched them to the corresponding Federal Circuit appeal docket from the Federal Circuit Dataset Project, which is a project that I've been working on for a while. It has all of these decisions by the Federal Circuit in it, but what we've recently been able to add is docket level information about every single docket that has been at the Federal Circuit since 2000 all the way up to, as of right now, September 30, 2021. And so what I was able to do is I was able to match all of this up to get at which final written decisions at the PTAB ended up being appealed to the Federal Circuit, kind of that iceberg as it's moving up. So if you want to access this data, you can access it at empirical.law.uiowa.edu. We've got it available. What's online is just decisions, and I think it runs through about April, May. I need to update the more recent decisions. Anyways, out of the total 2,477 PTAB decisions, 1,271 matched to an appeal docket at the Federal Circuit as of September 30, 2021. This indicates an appeal rate of final written decisions in IPRs of over 50%, over half of the decisions in final written decisions in IPRs. And it's actually probably even more than that because of the fact that some of these things get consolidated and some decisions result in more final written decisions being decided. But more than half, at least half of the final written decisions in IPRs at the PTAB get appealed to the Federal Circuit. Okay, so that's great for appeals, but what about Federal Circuit decisions? How many of these don't get settled but ultimately end up? It turns out that we've got at least 840 decisions from the Federal Circuit arising from final written decisions in IPRs. So a huge portion of the final written decisions by the PTAB end up in a Rule 36 or an opinion, a final decision by the Federal Circuit. Something like 40% at a minimum of inter partes review proceedings resulted in some kind of subsequent appellate decision at the Federal Circuit. So to the extent the director actively uses the power of the office to change the outcome of PTAB decisions in inter partes proceedings, those decisions will inevitably be appealed and the Federal Circuit will review the decision. And historically, it's the Federal Circuit's interpretation of the patent law that matters, unless the Supreme Court has something to say about it. Okay, so the second reason why I say that there's relatively little room for director patent policy maneuverability through PTAB review is that currently the Federal Circuit affirms PTAB decisions at a pretty high rate. Generally, the Federal Circuit seems to be saying that usually the PTAB gets it right. even in contested inter partes review proceedings. So to demonstrate this, I drew on all the written opinions and Rule 36 summary affirmances from 2015 to 2021, again, using the Federal Circuit Dataset Project, which has all these decisions in it. The top chart shows the rate at which the Federal Circuit finds some error in decisions in appeals from inter partes review proceedings over the past 6 years. The green is affirms in full, so no error at all. The kind of yellowish orange are affirms in parts, which means that there's some error, but also some not error. And the orange and red are vacates and reversals. So there must have been some kind of error in these. So what happens, overwhelmingly, the Federal Circuit affirms the PTAB in inter partes review proceedings. Remember, these are contested proceedings. It finds that there's some error, affirmance in part, reversal, or vacate, in 22% of decisions. I'll pause to note that there are a handful of these decisions that are like mutual dismissals where mutual vacates where the Federal Circuit and, the Patent Office and the appellant agree that there's some error and the Patent Office agrees that it's going to basically take another look at it. These are relatively rare, but they do exist. They're kind of hidden. They're on like a shadow docket, basically. Trying to get at them is a lot harder than getting at these opinions and Rule 36 decisions. So 78% of the time, setting aside those, the Federal Circuit affirmed the PTO in its entirety in inter partes review proceedings. Now, for comparison, the bottom chart shows the rate at which the Federal Circuit found some error in decisions in appeals from the district courts in patent infringement cases. So they're just patent infringement cases. These cases, of course, include issues other than Section 102 and 103, which is what's at issue in the IPRs. But overall, 29% of these cases for the same time period had some error correction. Only 71% were affirms in part. Put another way, the Federal Circuit affirms the PTO in inter partes review proceedings more often than it affirms district court judges in patent infringement proceedings. So basically, from my perspective, there just isn't that much PTAB error to correct. In fact, a director who reverses the decisions of the PTAB judges is probably going to increase the agency's reversal rate more than decrease it, unless the director is really good at picking winners. So I just don't think that there's some huge number of errors to catch here. And indeed, for IPRs, if the director reverses the decision of the PTAB judges, the now losing party has every incentive to appeal, which may result in the director being reversed on appeal and the decision of the PTAB judges being reinstated. Probably not a look that the director of the PTO wants. I think that there are just so many other opportunities for the director of the PTO to influence patent policy. Review of PTAB decisions, however, is just not one that I think is likely to lead to much meaningful impact on patent policy. A large portion of inter partes PTAB decisions are already appealed, and the Federal Circuit seems quite comfortable, for the most part, with the decisions that the PTAB is already making. To the extent the director becomes involved in review of PTAB decision-making, he or she will need to be careful not to toss too much pepper into the soup, thus resulting in a soup that gets thrown out by the Federal Circuit. That, I'm going to kick it back over to David.
All right, thank you. And now Dr. Shepard.
Well, first of all, I wanted to thank David Taylor and SMU and my, I hate to say, I'm reluctant to say colleagues, because Tejas and Jason are just so amazing at this. And Jason, as usual, you just outshine just about everyone with your facts and figures. I love coming to these, even though I do feel like I'm a little out of my depth, because it's refreshing to hear ideas and contrary ideas, even ones that I don't agree with, Tejas, from an academic perspective. And because it doesn't have the parochial restraints. And this has been great so far. And just really one quick thing, my house does not look like in a hotel room. I am at the AIPLA. It's been a great session this year. And as I mentioned before, I feel a little bit out of my depth. Why am I out of my depth? Because I'm a patent law person. And this is not about patent law. It's about the APA, administrative law. It's about constitutional law. And I love what Tejas just said was, when I was writing my notes and things, I was saying, I kept in my head saying administrative patent, administrative, the APA, Administrative Patent Act. It's not. right? Administrative Procedures Act. So we have to mesh these two things, not just here, but also in Congress and in policy. And one of the reasons I'm on this panel is because I was there when the sausage was getting made. The one thing I will say is I'm going to rely a lot on Adam Mossoff's kind of reflections on Arthrex for this case. So if you hear some things you've heard from Adam before, I'm giving him full credit. So for that. So here's a couple of things. Let's reflect back to why the PTAB was created. It was created because people thought there was a quality problem with the PTO. Specifically, there were these, there were abusive litigation techniques. I prefer to call it that as opposed to trolls, that were holding up innovation, that were extracting payments. And these people came to Congress, said this can't continue, blah, blah, blah. And what Congress did was a bunch of things, and one of which was to create the inter-parties, the new PTAB with two separate systems. And I think part of what Congress thought was that, one, we created this separate system which has to do with going, backwards into the post-grant, but we also have the new system under AIA. And I'm bringing this up because I believe the Congress has somewhat thought that this is nothing more than what they've done before, PTO did before, kind of rebranding and making it more fulsome. And more fulsome meaning that it is going to accomplish three goals. One, it's going to reduce administrative burdens, reduce administrative hassles for the courts. Two, it's going to be less expensive. And three, it's going to be faster. We really haven't had that much time since the AIA. I think it was September of 2013 when it first started. But we know some of those things have not come to pass. And drilling down into why those things haven't come to pass being cheaper, faster, and not having duplicate proceedings in different courts and that sort of thing, are quite honestly some things that probably needed to be corrected in subsequent legislation. And you may know that Leahy has a new bill, Restoring the American Invents Act, right? And the Restoring the American Invents Act is not just about reinstating the initial objectives, but it's also there to respond to some things that have happened along the lines because of, quite honestly, the political machinations of the fact that you have different directors every 2, 3, 4 years. And some of the other, parochial thoughts that people have, and that have changed how the AIA was first envisioned to how it works now. So moving on, because I think I told you this would take 5 minutes, but everybody else took more time. I will too. So the next was, so we look back to why it was created. I swear, I go to these conferences and things, and people just kind of forget like why it was created, and it had a very specific purpose, and whether or not it's doing that purpose is something that we have to look at. The next thing I want to talk about just really quickly is Arthrex. And I always have a hard time pronouncing that name because in my head I just think anthrax over and over again. And it's probably not inconsequential that I worked on Capitol Hill during the whole anthrax problem. But in any event, in anthrax, I'm going to quote Tejas here, that the Supreme Court just basically said, I don't care what Congress said, we're going to fix this and create this entire new situation, right? But they had a good, I think, objective here. They didn't want to call into question all the decisions that happened before. I mean, maybe they have. They gave it to the director to kind of fix this. So they created a new system with discretion. And that's where, Jason, I don't agree with you that that whether or not the discretion is good or bad, or what's the outcome going to be. I'm just going to say it's something we have to live with at this point. And how do we use that, do that and internalize it in a way that is useful? I love what Jason said. What I'm gonna say. He said it's not a good look for the director to be shot down because of its discretion, and maybe the director will add too much pepper into the soup. Well, I'm just going to say this really quickly. Quite honestly, the directors have been adding pepper into the soup by the boatload. Just back up the truck, dump it in. And having worked at the Patent and Trademark Office and having friends who are quite honestly, judges, when we first started having the PTO started looking for judges, I quite frankly sent out the advertisement to friends who worked at high-powered law firms. Not because I thought that they didn't like their job, because I thought that this could be a great place to, to really do improve quality and maybe a better lifestyle for my friends too. I will tell you that it has gotten toxic. And the reason it's gotten toxic is because some directors have already adding pepper in the soup, backing it up right to the soup, to the extent that the main threat is that there's you can work on two different things. You can work on reexaminations or you can work on AIA cases. I'm probably getting this wrong. The threat is, play ball or get sent over to the minor leagues. This happens over and over and over again. So the morale with its judges right now is very low. I will say that it's a little bit better. You can figure out why. Well, it was until 2 weeks ago or 2 days ago. I've lost time at this point. And part of the problem is that when the president nominates new people to come into the patent office, and unlike Yanku was there for 4 years or 3.5 years, which is unusual. Usually they don't stay as long as he did. What you end up having is there's been a change. You have people who are not just politicals, but what you have are large law firm attorneys who are running the patent office. It used to be people who didn't have these sort of interests who were running the patent office, people who knew the government, people who knew the patent office, people who knew administrative law, that sort of thing. And now we have people who leave private practice, they go to the patent office, they go back to patent practice and have the exact same clients. Does that ring like maybe a problematic to anyone? The next thing I want to say on that issue is, I just recently heard Anna Mossoff said the last thing you want in that position is the academic. But then I'm like, well, okay, who do you want in that position? And so I'm going to go back to greater quality, for greater quality, for the greater quality for what's coming out of the Patent and Trademark Office. How do you get greater quality out of any organization? It's the people who work there, concentrating on the people who work there. When you have these people who are basically, and I'm going to get in trouble for this, figureheads, who don't really interact with the people who work there. Capos was excellent at that. Capos increased patent quality. Capos increased patent quality. He increased the outlook of the agency. I think everyone was wonderful. A lot of things were not wonderful, went really well. And the USPTO became one of the #1 agencies to work for in the United States government. Morale was high. You might want to look at morale now. They take it every year. So, I'm just going to, that's kind of on the aside. But my point is that what Arthrex did was institute what was happening anyway. The next point I have is, and this is how I involved in thinking about this, is, well, aren't they just creating the International Trade Commission? So let's think about this for a second. The Supreme Court in Arthrex said, well, the PTAB is an odd duck. It's a very odd duck. And what do you think about when you hear duck? Like, if it walks like a duck, quacks like a duck, it's a adjudicated process, right? And this adjudicated process looks nothing like anything else. It's litigation. And not even litigation light anymore. It is straight up litigation. And that's what the Supreme Court sees. And that's why they said that we can't have this being done by inferior officers. So I think I do have a slide, and hopefully it won't take me very long to pull up. It's just an explanation slide of what the ITC does. Share screen, and it's almost, oh, there it is. Okay, it should just only take a second. Do you see this slide? It's not my slide. It's from Adushi, who I worked at the International Trade Commission, and I was with the Office of General Counsel's office, and so I've been part of this process. And actually, they were my co-counsel on some things, but it doesn't matter. So here's how the ITC works. And let me back up again. I'm going too fast. The International Trade Commission is the redheaded stepchild of the patent world, right? And why do I say that? Because quite literally, I was in Congress and people were, putting this thing before us. I'm like, did you intend to leave out the International Trade Commission? You know they do patent stuff, right? Oh, okay, we add them in. And what they do is they are under the Section 337 of the Trade Act. Is they review patents for validity and infringement. Sound familiar? But they don't give monetary damages. What do they give? They stop the infringing item at the border. They've become more and more popular, specifically after the eBay decision, because they can give injunctions. And these days, injunctions by stopping things at the border are more important than anything else, because most things are not made in the United States. So this is the timeline of the ITC. The complaint is filed. It is reviewed by the commission to determine whether or not it should be instituted. Ring a bell? The institution is initiated. There's discovery, pre-hearing, Markman-like trials. They have the hearing. They have post-hearing filings. They're the judge's decision, and this is the important part. They have the commissioner's review. So, as part of the International Trade Commission's Office of General Counsel, what we did was look over these decisions. We looked over like all of the filings and things, and we looked to see whether or not for two things. One, we looked to see if the commission should have a different decision than the judge. The second thing we looked at was public policy interest, and I'm going to get the exact words right. We looked at if there would be unacceptable harm to the public. So that's where Tejas's position comes in. Is it out of line for the PTO director to have this policy review? I don't know, but there's a precedent. And not only does the commissioner review it and say you don't like the commissioner reviewing it, that's fine. The president of the United States also gets a 60-day or 90-day, 60-day period to review for harm to the public, unacceptable harm to the public. If the commission agrees, that is when we have the final order. So the final order is not the final order of the judges, it's the final order of the commissioners. So if it's appealed, on the appeal portion, it is the party versus the ITC. So that's why when I was at ITC, I got to argue before the Federal Circuit. So I look at this in parallel to the Arthrex decision, and I know that there are people on the Hill who kind of think that maybe the best way to set this up to make it comply with the APA or other things without reinventing the wheel is to make it more like the ITC. And the reason I like that so much, and I wasn't there before, but now at the Arthrex, I'm completely there. Why? Because this is the first step towards that. And what the AIA did was unintentionally, for the right reasons, everyone thought it wasn't going to be this juggernaut that it is now. And since we're dealing with lawyers and lots of money, who's surprised that people found ways to make the system work for them as opposed to make the system work for the public? I'm going to end there because I've probably gone way over my 5 minutes. But the ITC model, I really think is something that people should look into. I did some research and I'm like, no one's talking about this. And I think I found one article behind a paywall. And there probably is some very good reason why not. But at the same time, I'm shocked that the academic literature isn't talking more about it. And particularly the problem with the revolving patent directors. I just have a massive problem with that. The last thing I'm going to say, which is completely off topic, is that I'm looking over the Potomac right now, and there's this giant Ferris wheel over here, and I'm on the flight path of the flights going to the Washington National Airport, and I just think to myself, this is this patent system is such a great thing, and such we all know it's literally in the Constitution, and we keep finding ways to screw it up. And it's not because Congress or anyone else wants to screw it up. They're doing their best. The people who screw it up are the people who have legitimate business interest, and the courts and Congress and others are just trying to keep riding the boat that keeps getting off kilter, off center. Okay, thank you very much.
Great, thank you to all of you for your opening remarks. So let's go back to Professor Narachamia. I'm struck by the seeming incongruity between the purpose of the Appointments Clause, political accountability, and the idealized role we have of judges, which I think is insularity from politics. But here we are, and I'll go back and mention the Oil States versus Greens Energy case, right? The Supreme Court decided that patent invalidity disputes were not required by Article 3 or the 7th Amendment to be held in federal court. So we have the PTAB. It has this permission by the Supreme Court to rule on invalidity. You seem to have a different view with respect to the role of politics in the invalidity dispute resolution mechanism. So I just want to follow up and ask, are you not concerned with the role of politics within the PTAB? And let me follow up on that. So, is it just legal realism, right? Politics are there, let's just recognize it. And maybe that's, let's not ignore the elephant in the room or the donkey in the room, depending on who's in power. Or is this a normative position that politics should be part of the invalidity analysis? And if so, what is that role? And by the way, if you like politics involved in picking judges or the way judges act, come on down to Texas. We elect our judges here in Texas.
So it's a great question. I think it's a little bit of both, right? I think if I had to pick, I'd say it's the former. It's this legal realism point, which is that the way you said it, politics or priors or patent ideology is unavoidably a part of every patent examination, of every PTAB decision. Maybe not every, but there is some element of what we bring from our life experience to our job at the patent office that will color the way we do the job of patent administration, and so we should have some sort of democratic check on that. So look, let me start by that's my general answer to your question. I'm happy to stop there. I also have a few other related responses to the things that Crystal and Jason said. I can wait on those or put them in. But one thing I do want to say is in response to you is that the irony is not lost on me here, that it's the least accountable institution in our political system that has imposed this political accountability requirement on the patent office. And I think that's also something we're thinking about. And I think it's a bigger question. It's well beyond the scope of what we're talking about today. But I think it's worth thinking about what sorts of democratic or legitimacy checks we have on the court and the courts as they go through this, as they go through, both dealing with questions of the Appointments Clause, but also, run-of-the-mill patent infringement cases. And we talked a little bit about that in the previous panel. So I'm happy to stop there. I'm also happy to keep going. It's up to you, David.
Sure. I would like to hear your response to the other panelists.
Okay. So I think I have 3, maybe 4-ish responses. Jason, there are a few things that you said at the beginning of your remarks that I think I just want to try to address directly, not antagonistically, I hope, but sort of in a way that I think I agree with you in some senses, but I think we disagree with how that cashes out. So one thing that you said is that you are a little worried about the role that patent ideology or patent politics would play when it comes to rights that are conferred by the government on individuals. And I think I have a slightly different take on what a patent is, and a slightly different take on how unusual or problematic that could be. So I think of the patent primarily not as an individual right, but as a right held against the public. Right? So I think that what we do is we take information from the public domain and protect it in the patent for a limited amount of time, and then we give it back to the public. And so if we think of the patent as primarily a right against the public, right, to me, it makes a lot of sense then the public should have some sort of check on the process by which we take things away from the public and give them to individuals for a limited amount of time. But even if we think about this as an individual right or a right that one person has, what Arthrex recognizes is something that's quite common against the administrative state, across the administrative state. I'm going to take something of an extreme example, but I'll take the immigration case. Right, so immigration cases are about, in a lot of cases, one's right to stay in the country. Right, I would call that far more fundamental than a patent right. But yet, right, the process of an immigration case goes from an IJ, an immigration judge, to the BIA, the Board of Immigration Appeals. Those decisions can be certified to the Attorney General, the head of the agency, a political actor, removable by the president. And so, there are lots of places, and the Wasserman and Walker article you talked about earlier references this, that it's quite common across the administrative state to have this sort of agency head review. And so if we're worried about the second thing that you said, the president or political leadership rewarding allies or punishing those that are out of favor, I'd say, yeah, that's a risk. But depending on your perspective, you might say that that's a risk that we face in the immigration system. But with that risk, at least with this model, comes some form of recourse. Right? If you thought immigration policy was terrible, then you could vote against it. If you liked immigration policy, you could vote for it. Likewise, if you don't like our patent policy, you can vote for it, or you can vote against it. And if you like it, you can vote for it. And that takes me to the third thing you said, which was about the average voter probably doesn't care too much about patent policy. So a few things. So if you asked me 3 years ago whether the average voter would care about who the political leadership was at the CDC or the FDA, I think people would say no. But right now, people care quite a bit. So this is the sort of thing that I think doesn't matter until it does matter. For some voters, maybe they do care about patent, right? Maybe some of the lawyers in the audience, maybe some of their clients care a lot about who leadership is, and they might be single issue voters. There probably aren't very many single issue patent voters, but there might be some. Most voters anyways aren't single issue voters. But many voters might care about the sort of corruption that you talked about, right? If what we see is a political system that is consistently favoring allies and punishing others or acting in ways that appear to us to be corrupt, whether it's in the immigration system or the patent system, then I think it's important for us to have that sort of recourse, that political recourse. So this is the last thing I'll say is so I agree with you that the number of cases that the director is likely to intervene is low. But I think I disagree with you, and I agree with Crystal that PTAB decisions, I think, are a good mechanism for making policy. I think FinTIV is a great example of that. The director is very involved. This was happening anyways. And so the question is, if this is happening, if the director is having some effect on the decisions that the PTAB is making, should we make the director stand up, take responsibility for it? And for the voters for whom this matters, should they have the opportunity either to do something in that moment or to respond electorally thereafter? I'll stop. That's it.
All right. Of course, I'm going to turn it over to Professor Rantanen to respond.
Sure. So you got some great points, Tejas. And I mean, I think that your view of the patent right as a right being held against the public, right? I think that has some great weight there. I think that's really important. I do want to think also, though, that these decisions are not just should the public take back a right that has been given against it, but also is this right being given more, right? Giving more away. And I think that's important. I want to think a little bit more about this, though, when we think about the nature of inter partes review disputes. And I think there are some key differences from your example of immigration policy. And I'm going to give two. So I think the first is that these are disputes between private parties. And I think that is really critical. If we envision these kinds of inter partes disputes as essentially being a proxy for litigating this proceeding, this patent issue in the district court, which is how they were in large part envisioned, this is a dispute between two private parties. An immigration dispute is not a dispute between two private parties. It's a dispute between the government and the person who is seeking immigration status, the person who's seeking to stay in the country. So I think that's a key distinction. I think that's why due process concerns become even more significant in the inter partes review proceeding. I think they're really significant in the immigration process, but when we think about disputes between two parties, we often think from a civil perspective, is there a thumb being placed on the scale in favoring one of these parties? And that goes to the second point that I think is really important distinction, which is that these are commercial disputes. These are business disputes between two business parties. And we know that one of the best ways to get a business return is to increase investment in lobbying government officials in order to get your preferred outcome. And so if we think of these as business disputes, it makes great sense for companies seeking to obtain the best business advantage to secure an exclusive right against the public to invest very heavily in lobbying in that particular space. And I think that's the other part where I see these as being quite different, and where I do very much have concerns about the amount of political influence in these disputes between two private parties, where you have the potential for seeing great investment in lobbying to favor the party that has that wants this particular exclusive right or doesn't want the exclusive right. So those are two things that on my immediate response that I'm troubled by, and I want to differentiate these by. The second major point that you made, most issues aren't single issue voters. I think you're probably right. There are very few single issue patent voters. I think at one point when I was like 10, if I could vote, I was going to be a single issue space voter. I was only going to vote for people who are going to develop hyperdrives and send us to space. But I don't think most of us are like that. And I think that we are multi-issue voters. And I think that this is probably for most people relatively low. And the corruption point, this is really something that troubles me greatly, which is whether we as a society and we as a polity would say, no, this type of political favoritism on an individual level is bad, and we're going to reject political candidates, political officers who are in this, or if instead we say, oh, as long as the corruption favors us, right, in my position or my party, then I'm going to be totally cool with it. And I think that to me is such a deep and troubling concern. I don't have a good answer on that one at all. I think that raises much broader questions that maybe some of my colleagues here at Iowa would have great things to say about. But no, that's one thing. Your last point on PTAB decisions as a good mechanism for making policy. I'm not convinced that these individual disputes between parties are nearly as a good mechanism as other forms of decision-making, other forms of rulemaking or guidance that the director can use, especially in a prospective way rather than retroactively affecting the rights between parties. And so I think there are just so many better tools that the director can use than this particular mechanism, which I think is very, very fraught with a lot of concerns. And I could see directors being very, very hesitant to use this mechanism.
So I love this discussion, but let me just highlight an interesting parallel between this discussion of the PTAB and the last panel, actually, with respect to district courts. We just mentioned the FinTIV factors, which are factors that the PTAB, the director, came up with to govern joinder of different petitions and the ability to, but the basic point I want to point out is that was a procedural issue. And in the last panel, we focused on how district judges have used procedure and shaped procedure to attract cases, perhaps. But at any rate, those procedures tend to benefit patent owners, it seems like. At least patent owners seem to think so. And here we have the patent office and the director using procedure to perhaps go in maybe in a little bit opposite direction. It favors the patent, well, actually, I think in the same direction. It favors the patent owners, but does not favor the people who file the petitions. But it occurs to me we have the same issue of procedure being very, very important. But I also want to highlight, in the last discussion, we were talking about forum shopping. And so I guess, Professor Rantanen, I'll ask you this question, but are we concerned with forum shopping by potential infringers when they go to the PTAB? And if we allow politics to be injected, maybe it depends on who's in charge and what their politics are, but aren't we going to perhaps further or impact this idea of forum shopping, or are we going to have forum selling potentially? Do we already have it?
I guess I'm not totally following you, David.
Yeah, so at the PTAB, do we have forum selling going on? I mean, Congress perhaps is trying to create this alternative mechanism to federal district courts, and then we have the people in charge of that forum only really being in control of procedure, right? So it's a parallel to the federal district courts where they can say, I'm going to adopt certain procedures that may encourage people to file here or may discourage people to file here. Is there forum shopping going on? Is there forum selling going on at the PTAB? And I'll throw that out for the whole panel. I don't know.
I mean, I think fundamentally the whole idea of IPRs was to create an attractive mechanism to litigate these disputes in another form, and there were specific mechanisms even within the statute itself that incentivize the filing of these, and also have some costs, but mostly incentivize the filing of these. So I guess that's where I struggle, which is the whole system was set up in order to channel some of the disputes that were in district courts into a shorter, faster, quicker, perhaps by expert judges, determination in the PTO. So I get that's where I struggle. Is the whole idea is to create this alternative mechanism where you have incentives to use it to get quicker resolution.
Right, and so we're criticizing almost all of those same ideas when a particular judge does that in a federal district court, but we seem to be, well, we like that with respect to the PTAB. Maybe it gets to the point that was discussed in the last panel. Well, as long as we have a democratically justifiable mechanism that resulted in this choice, we're perfectly happy with it. I don't know if Dr.
I mean, Congress created it, so I'm, right. And if Congress did the same thing with this mechanism, then, I think I would be much more comfortable with what the Supreme Court did if Congress had done that instead. And so Congress creating the forum shopping, I don't know, I feel more comfortable with that. What do the other panelists think?
I think we'd all be more comfortable if Congress had created it, but as we know, Section 101, I'm sick of talking about it, and Congress hasn't fixed it. The Supreme Court keeps saying things, and then the rest of us have to deal with it. I have to agree with you here, Jason. It's just I'm just gonna leave it at that. Thanks.
Well, maybe it's a bad question. Let me go on, and actually, Dr. Shepard, let me stick with you, because we've been talking about basically we had a system, right? It was the PTAB judges. They were the final word on invalidity, and the Supreme Court blessed that in oil states, and they said we don't need federal judges to rule on invalidity. It's okay for our non-Article 3 dispute resolution, we'll call them judges, PTAB judges, to resolve those disputes. Now we have a different system, right? We know now we have the presidentially appointed, Senate confirmed director of the Patent Office, who ultimately is responsible given the Supreme Court's decision in Arthrex. But you've highlighted this other way, right? There's another path to go down, and mentioned that there may be some interest in Congress. So I'm just wondering, it sounds like you're very in favor of a commission model that would take Congress actually setting that up, right? And I just wanted to see why you think that's the better approach in particular, and then get others' responses, because Congress could change the approach. The Supreme Court set up this system, as we just mentioned. There was, at least in one response, the last question was, well, if Congress sets up the system, then that's a great thing. It's kind of weird that the Supreme Court set up the current system. So why do you like the commission model?
To be honest, I didn't like the commission model until I just kept seeing the until I saw the what the solution was. And you mentioned that the problem is corrected with anthrax. I'm not really sure that it is. There's been so many lawsuits, and I believe there'll be more. The other part is that the Drew Hirschfeld has reviewed some of these cases, and he is not appointed by he's acting. So I wonder what's going to happen with those. And when I kind of went through my head to say, okay, what is the solution here? And don't get me wrong, I know academics, you are fantastic. You're fantastic, but we can't put the toothpaste back in the tube, right? So what do we do at this point? What we do at this point is, okay, what are the possible solutions? Some people have said, we'll make the PTAB judges Article 3 judges. I don't know what the hurdles are for that. It sounds like it's not going to be possible. There's also people are saying one and done with the appeals, with the estoppel provisions in the AIA trials, because there's just too much gamemanship. Okay, maybe again that's something that's going to have to be done by Congress. What about the changing the from clear and convincing and instead from a preponderance of the evidence to clear and convincing? Well, probably the director could do that. So I kind of look to all of these solutions given what we have now, and I come back to we're getting closer and closer to this other model that already exists. Is not going to have the Supreme Court challenges that we see now, and are going to continue, and that's where I land. I do have a couple of other quick, comments on some things that the others have said, which is, I think Brett who said it, but someone said that there's politics in all parts of patenting, and I need to back up there. There is no politics in patent examination. The politics come in at the higher levels, and the system is set up to be politics free. The examiners are not sitting there deciding, oh, well, do I think this, yes, they come with their own life experiences, but I cannot think of one examiner who under Section 101 says, oh, I don't think that drugs should be patentable, so I'm just going to deny this. They wouldn't have their job for long. And what we see at the higher levels is a lot of political wrangling. And when someone said earlier about the political litmus test and these things happening with the director, why do you think it took so long to the director this time? There is a political litmus test. And we look at the administration now with the waiver for COVID protocols. We look at Congress, who is actively having hearings and talking about ways to reduce drug costs. So when you talk about single issue voters, I can guarantee you there's single issue voters out there who would vote based on how much drugs cost. And they think that it is based on the cost, the patents, which is not necessarily true. I can go on and on about that, but I will not. So, democratically legitimate. I don't like the fact that things are happening in the shadows, and shining a spotlight on it. Sunlight is the best disinfectant. So I really have come around to thinking that that may be the only and best solution to a problem we didn't create, no one really wanted, but we have anyway.
Great. So I definitely want to hear other panelists' reaction. And by the way, we have about 7 minutes left. So if you have a question, if you're in the audience, submit a question and answer, and we'll get to it. But I want to hear the other panelists and their views of a commission model.
So I'm happy to jump in. I think the commission model is actually not a bad idea. I mean, assuming that you can get it past the court again, right, which has expressed some increasing skepticism for new commissions, new agency structures that have some measure of independence from the president. But right, the ITC, Crystal, as you talked about, has this sort of White House presidential review mechanism. I think it formally goes to USTR, or maybe the president has delegated to USTR. I think so. I think I want to agree with Crystal and Jason that I think a commission model would be great. I also think that rulemaking is a better mechanism for doing some of what the director is doing over adjudication. But we have the agency that Congress has given us. We have only the powers that Congress has given us. So I would love it if Congress created, an intellectual property office that was, or the intellectual property commission that had a set of commissioners, that had rulemaking power, that had presidential review. I think that would be I think that would be an improvement over the system we have now that brought the PTAB in, would have more transparency, would acknowledge some of the political realities. And one thing that I'll say quickly in response, Crystal, to what you said about there not being politics in examination, I'm not sure. So Melissa Wasserman and Michael Frakes have this really interesting paper where I think it's called Patent Office Cohorts. And what they do is they look at new examiners and when they came into the system. So new examiners came in during different eras of patent examination guidelines. Some guidelines are more permissive, some guidelines are more restrictive. Whether those guidelines are permissive or restrictive is a direct function of the director, who is the political leadership. And it turns out that no matter who the director is at the time, you learn how to do examination. You learn to be permissive, you learn to be restrictive. And so there is an element of politics. And you might even, like, if you wanted to be really controversial about it, you might even call it deep state resistance to the prevailing leadership of the agency based on sort of your learned mode of examination. And so there is this element of politics, even at the examination level, based at least in part on what you learned when you started at the agency, and maybe also how you feel about the patent system, you, the individual examiner. But I want to make sure I leave some time for Jason and for questions.
Great. Well, thank you so much. And I think it's a really interesting idea, and I do encourage you to write on it more. Somebody to write on it more. This idea. I want to, in addition to the thoughts that Tejas said, I want to raise two other thoughts. One is that we may want to be, one of the limitations of the commission model is if you don't have a quorum, you can run into real problems. So think about like the Federal Elections Commission, right? You know, a quorum, you can't really act. And so thinking about, are we actually, do we end up as an FEC at some point? Are we going to have a commission that continues to be functional? That's always a risk with the commission model. The second thing to think about is numerosity. So a really quick search on the ITC's website. ITC has received 387 Section 337 complaints since 2014, so 387. Between 2014 and 2021, the PTAB has issued 2,400 final written decisions in IPRs, and that's just final written decisions. That's not institution decisions, that's not filed petitions. It's a huge order of magnitude. And I think that one of the issues with the commission model, if we're going to be thinking about it, is how do you scale up, right? It's one thing to have to decide, 50 or 70 cases a year as a commission. It's another thing to have to decide 500 or 800 cases a year as a commission. And so that would be one thing to really think about, is the scale problem with the kind of a patent commission or a PTAB commission versus the ITC. Kind of bringing this back more broadly, I think one of the core questions for me is how much should politics be interjected into individual patent decisions, as opposed to the patent system as a whole, or maybe rules made in the patent office, but how much should politics be interjected into individual decisions? And IPRs, patent applications, they both raise that question for me. I recognize that at one point we had Congress very, very involved in individual decisions on patents, right? Again, to bring up Adam Mossoff, he's written a lot about this. Herb Hovenkamp has written about this. We've had Congress being involved in extending patent terms, reviving patents, right? Things like that. That was in the 19th century, early 19th century. How much is that a good thing as a normative question of having politics interjected into individual patent decisions? That to me is a big normative question here. And a second one is how much should we detach substantive decisions on patent rules from the district court infringement proceedings? And you talk about like an IP commission, right, where the IP commission sets the rules on what patents are, and maybe the district court's only job is to determine infringement, right? Just thinking really outside the box. Maybe that's a model we think about, but I would really want to think about it very, very carefully.
Great, thank you. And did have a good question come in. Moderator's privilege here. I'm going to pick one of the questions in light of the time that we have. I mentioned earlier this idea that the PTO doesn't have a lot of ability, the director doesn't have a lot of ability on substantive issues that's focused on procedure. And so a question came in, if the PTO is becoming more like other agencies with director review, the revolving door problem, we'll call it, I guess, is it time to bring the agency in line with other agencies by giving the PTO substantive rulemaking authority? So whichever one of you wants to jump in on that.
I'm on record as having said yes, and I'm happy to say that again. Yes, the PTO should have substantive rulemaking authority. I think it's ridiculous that it doesn't. And I think the agency does a lot of sub silentio rulemaking already through the issuance of examiner guidelines and other things. But the problem with that is that the agency does this already, but it does it in ways that is inconsistent with or is potentially in tension with the way we would want agencies to engage in rulemaking. Right? The director issues guidelines, they go into effect immediately, and then it takes comment on them afterwards. That's backwards. And so giving the agency rulemaking authority and forcing the agency to use it, I think would be better than the system we have now. And I think the status quo is the relevant comparator.
I think this is a very difficult question for a couple reasons. One is that we have this long history of district courts and judges deciding substantive patent rules, and I think that creates a tension. One of the key questions to be solved if we do this is, how do we prevent complete delamination between what the patent office's substantive rules are on patents and what the court system's substantive rules on patents? And maybe this is just foreshadowing our next panel, right? What's the role of the Federal Circuit? But how do you reconcile these two totally different substantive rule systems that could emerge? To me, that is the single most important underlying question. I totally agree with Tejas, though, on the PTO's rulemaking. I think there's been many comments over the years about the PTO's kind of interesting way of doing things. The MPEP, it's almost like it's like rules, but it's not really rules, right? But it's like the rules. It's what you get tested on. And so there's a lot of kind of deep administrative problems with, I think, the way that the Patent Office has gone about quasi rulemaking that I think we really need to think through, and I think Tejas has some great points on that.
Can I just add to that when Tejas said deep state, I hate that term. I hate it so much, but you're kind of right here. Between the fact that this rulemaking process, I hate to keep going back to 101, but it's the thing that's like, it's the horror that won't go away. is the executive guidance, is that even in line with the Supreme Court? And yet, this is what, as Jason said, this is what we're tested. This is what I have to teach my students. So I don't want to say that the current PTO and PTAB is broken, but I will say that the fact that we have so much litigation, I mean, it's something like six Supreme Court cases in the 10 years, just means that, do we do this piecemeal, or do we want some settled law here? I have to say, like with the other two, rulemaking is essential, whether it actually happen. I've been in the room when the conversations happened, and that's a really hard ask.
All right, well, we're over time, and actually I've got the time right this time, so I know we're over time. But anyways, it was an excellent discussion. I want to thank every panelist, not just this panel, the previous one. It's all been great today. Thank you so much. So we're going to take our break. This is our lunch break, even if you're on the East Coast, maybe a late lunch, but we'll come back in 56 minutes. That's 1 p.m. Central time. So and we'll have our last panel of the day. Okay, thank you.